Hi there! If you're planning for the future, one of the most important things you can do is create a solid estate plan. In today's video, we're going to walk through the top 10 estate planning mistakes and how you can avoid them to protect your legacy. By the end of this video, you'll know the top 10 mistakes to avoid in your estate planning process. If you fail to address these mistakes, it could lead to costly legal fees, delays in distribution, or even your assets going to the wrong person. So, let's dive in and get started. You know, folks, it just boggles the mind how many people put off creating a will. They think they have all the time in the world or that it's only for the wealthy. But let me tell you, that kind of thinking is just plain wrong. Not having a will is like walking a financial tightrope without a net. Without a will, you're essentially leaving your financial fate up to the courts. Can you imagine that? Strangers deciding what happens to your hard-earned money? Dying without a will can lead to a long and expensive probate process. We're talking about lawyers, court fees, and delays that can drag on for months, even years. Creating a will is one of the most important things you can do for yourself and your loved ones. Trust me, it's worth its weight in gold. Alright, so you've got a will. That's great. But hold on a minute, don't get too comfortable just yet. Life is full of surprises, isn't it? You get married, have kids, get divorced, move states, win the lottery. Hey, a guy can dream, right? The point is, things change, and when they do, your will needs to change right along with them. Failing to update your will is like trying to navigate with an outdated map. You might end up lost and confused, and in this case, it could mean your assets end up in the wrong hands. Your will should be a living, breathing document that reflects your current circumstances. Review it every few years or whenever a major life event occurs, and make the necessary updates. A little bit of maintenance now can save a whole lot of heartache and headaches down the road. Now let's talk about something called powers of attorney, or POA for short. This is a crucial topic that often gets overlooked but can have significant implications for you and your loved ones. These are essential documents that give someone you trust the legal authority to make decisions on your behalf if you become unable to do so yourself. It's not just about having a piece of paper, it's about ensuring that your wishes are respected and your affairs are managed according to your preferences. Imagine this. You're in an accident or come down with an illness that leaves you incapacitated. In such a scenario, the last thing you or your family would want to worry about is who will handle your responsibilities. Suddenly, you're unable to pay your bills, manage your investments, or make healthcare decisions. The stress and confusion can be overwhelming, not just for you, but for everyone involved. Without a POA, your family would be left scrambling, trying to figure out how to handle your affairs. They might face legal hurdles, delays, and additional stress during an already difficult time. A durable power of attorney for finances allows your designated agent to step in and manage your money matters. This includes paying bills, managing investments, and handling other financial transactions, ensuring that your financial life remains stable. Then there's the healthcare power of attorney. This is equally important as it covers medical decisions. This document appoints someone to make medical decisions for you if you're unable to communicate your wishes. It ensures that your healthcare preferences are followed, whether it's about treatments, surgeries, or end-of-life care. Having powers of attorney in place provides peace of mind, knowing that someone you trust is there to make decisions in your best interest. It's a proactive step that can save a lot of heartache and confusion down the line, making sure that your life continues smoothly even when you can't be at the helm. Okay, this is a big one, folks, so listen up. Beneficiary designations. These are the forms you fill out when you open a bank account, retirement account, or life insurance policy, and they determine who gets that money when you're gone. Beneficiary designations often override your will. Even if your will says one thing but your beneficiary designation on a specific account says something else, guess what? The beneficiary designation wins. Let's say you get divorced and forget to update the beneficiary on your 401k. Even if your will leaves everything to your new spouse, your ex could still end up with that retirement money. Review them regularly and make sure they align with your current wishes. It's a small step that can make a world of difference. Now, let's talk about something nobody likes to think about: taxes. It's a topic that often brings a sense of dread, but it's crucial to address, especially when it comes to estate planning. Yes, even in death the taxman may come knocking. Estate taxes, also known as death taxes, can significantly impact the wealth you leave behind for your loved ones. Estate taxes are levied on the transfer of property after someone passes away, and depending on the size of your estate, they can take a hefty bite out of your hard-earned assets. This means that without proper planning, a significant portion of your estate could go to the government instead of your heirs. Estate tax exemptions can change, and what's exempt today might not be tomorrow. Tax laws are constantly evolving, and staying informed about these changes is essential to protect your estate. Plus, even if your estate isn't currently subject to federal estate taxes, many states have their own estate or inheritance taxes. These state-level taxes can vary widely, so it's important to understand the specific regulations in your state. The good news is, there are ways to minimize estate taxes and ensure that more of your wealth goes to your loved ones. By taking proactive steps, you can significantly reduce the tax burden on your estate. Strategies like setting up trusts, making lifetime gifts, and charitable donations can all help reduce your taxable estate. Trusts can provide a way to manage your assets and distribute them according to your wishes, while gifts and donations can lower the overall value of your estate. Talk to a qualified estate planning attorney or financial advisor about your options. These professionals can help you navigate the complex tax landscape and develop a plan tailored to your unique situation. Create a plan that protects your assets for generations to come. By planning ahead, you can ensure that your legacy is preserved and that your loved ones are taken care of long after you're gone. Alright folks, let's talk about organization, or in this case, the lack thereof. Creating an estate plan is only half the battle. The other half is making sure your loved ones can actually find it when you're gone. Failing to keep your estate plan organized is like hiding a treasure map, but forgetting where you buried it. Create a system for organizing your estate planning documents, and make sure your loved ones know where to find it. You can use a physical file cabinet, a safe deposit box, or even a secure digital vault. Don't leave them in the dark. Now let's talk about something that's near and dear to my heart, your children. As parents, we all want the best for our kids, and that includes planning for their future, even in the most unexpected circumstances. If you have minor children, naming a guardian for them in your will is absolutely crucial. This isn't just a formality, it's a vital step in ensuring their well-being and stability. This is the person who will step in and raise your kids if you and your spouse are both gone. It's a role that carries immense responsibility and requires careful consideration. Failing to name a guardian is like sending your kids out into the world without a safety net. Imagine the uncertainty and fear they might face without a designated guardian to guide them. If you don't designate a guardian, the courts will decide who takes care of your children. This process can be lengthy, stressful, and may not result in the best outcome for your kids. And let me tell you, the courts don't always get it right. The judge may not know your family dynamics or your children's specific needs, leading to decisions that might not align with your wishes. Choosing a guardian is a big decision, and it's not one to take lightly. You need to think about who would be the best fit for your children, considering their emotional, physical, and educational needs. Think about someone who shares your values, who you trust implicitly, and who has the time, resources, and love to raise your children as their own. This person should be someone who can provide a stable and nurturing environment. Once you've chosen a guardian, talk to them about it. Make sure they are willing and able to take on this responsibility. It's important to have an open and honest conversation about your expectations and their capabilities. It's a conversation that could make all the difference in your children's lives. By planning ahead and naming a guardian, you're providing your children with a sense of security and continuity no matter what the future holds. Now for all you entrepreneurs and business owners out there, this one's for you. Failing to plan for business succession is like building a successful company, but forgetting to create an exit strategy. Think about it. What happens to your business if you suddenly pass away or become incapacitated? Who takes over? A business succession plan outlines what happens to your business in the event of your death, disability, or retirement. It identifies a successor, outlines the transfer of ownership, and ensures a smooth transition. Without a plan, your business could end up being sold off at a fire sale price, or worse, it could crumble without your leadership. So, if you're a business owner, do yourself a favor and create a business succession plan. Alright folks, we're nearing the end of our list, but this next mistake is a big one. Creating an estate plan is only half the battle. The other half is communicating it with your loved ones. Think about it. What good is a will if nobody knows where to find it? What good is a trust if your beneficiaries don't understand how it works? It's crucial to have open and honest conversations with your family about your wishes. Explain your estate plan in simple terms, answer their questions, and address any concerns they might have. It can help prevent misunderstandings, reduce the potential for conflict, and ensure that your wishes are carried out according to your plan. Talk to them, explain your plan, and give them the peace of mind they deserve. And finally, the number one estate planning mistake is procrastination. That's right, folks, putting it off, dragging your feet, waiting until tomorrow what you can do today. We've all been there, haven't we? But here's the thing about estate planning: tomorrow is not guaranteed. None of us know what the future holds. We could get hit by a bus tomorrow, or we could live to be 100. The point is, we just don't know. Procrastination only leads to regret, and in this case, it could mean leaving your loved ones with a financial and emotional mess. Start planning today. It's one of the most loving and responsible things you can do for yourself and your family. Get started today. Now that you know the top 10 estate planning mistakes to avoid, be sure to check out our next video on how to create a foolproof estate plan that covers all your bases. You won't want to miss it.